Manhattan District Attorney's Office has until 10 a.m. Eastern Time to respond after President-elect Trump filed an emergency petition asking the Supreme Court to block the sentencing in his New York criminal trial, which is scheduled for tomorrow. Trump's legal team argues the sentencing should be delayed over claims of presidential immunity.
Former federal prosecutor Katie Cherkasky joins us now. And to be clear, when Carly says Supreme Court, we're talking like the U.S. Supreme Court, not a state court. This is as high as you can go. How should the court rule?
Well, I think that the Supreme Court should absolutely stay this sentencing, and there's a very good reason for that. And in terms of the timing here, this is really a crisis of Judge Merchan's own making. It's a manufactured crisis in terms of the timing. He has known all along that the Supreme Court's immunity decision, which came down in July, explicitly said that any sort of use of evidence of presidential immunity or acts that are immunized, essentially, entitles the defendant to immediately appeal that order. Because if you are immune from prosecution, or if there's evidence that you are immune from having used against you, that is something that needs to be reviewed immediately before any further steps in the case can be taken, especially including sentencing. So for that reason, I do think that the court should pause the sentencing to review whether this case is irreparably harmed and needs to be reversed.
Okay, but if the sentencing does happen, I'm sure many people are wondering this. I mean, what do you think it could possibly be?
Well, according to what we already saw from Judge Merchan projecting what may happen here, the sentence itself is going to be essentially symbolic. It's going to be negligible. It's not going to be any sort of jail time. But the big point of this is that before Trump can officially be considered a felon,
that's
a
what
convict,
this is all about.
They need to finalize this case and enter a sentence, even if it's just a minimal sentence. And practically speaking, they can't have anything against him that would follow him into office because they can't have any sort of conditions of release on him or control over him while he's in the White House. So it's just the fact of entering a sentence to finalize this case that they're so desperate to do, which needs to be stopped.
The procedural back and forth on this has been dizzying, so much so that lawyers can't even follow it. So if you're trying to figure this out at home, don't worry about it. You alluded to the evidence, and I want to focus on that because to me, that's where the fruit is. And the fruit of the poisonous tree doctrine. If the jury used testimony from a Hope Hicks that occurred during a conversation while Trump was president in the Oval Office, and the Supreme Court said conversations like that are immune, doesn't the entire conviction need to be overturned because of this fruit of the poisonous tree doctrine?
Well, I can tell that you are a lawyer, and that's actually exactly the point here. The big question is, does any use of this evidence entitle the case to be completely overturned? And I think the answer is yes. But even if the answer is we don't know yet, the issue still needs to be reviewed before anything else can proceed here. But yes, essentially, I think it's structural error in the case and would require a reversal of the conviction altogether.
Okay, so there's also this. Attorney General Merrick Garland is intending to release the first volume of Special Counsel Jack Smith's report on Trump's federal election case. So what's going to happen there?
It's a desperate attempt. It is an inversion of the presumption of innocence. This case was dropped. He has absolutely no legal basis to proceed with this, in my opinion. And obviously, there is ongoing litigation to stop that from happening. Totally inappropriate.
And let's be clear, this is the election case, not the documents case, which Judge Cannon said, you can't release this. And I think it's important what you said, because, yes, we have you here for your legal analysis, but you don't need to be a lawyer to analyze what Merrick Garland just did. This is PR 100% of the way. There's no legal basis. There's no legal rationale for what he did.
Absolutely not. They had their chance to get this conviction. They had an indictment. They had the superseding indictment. They were not able to convince the American people. Now they want to throw this out there to suggest some sort of criminality before proving anything in a court of law. It's offensive to the Constitution.
And I am most certainly sandwiched between two lawyers. A thorn between two litigators.
But Carly, for so much of this, you don't need to be a lawyer because it is either common sense or it is not law. And
it's like something no lawyer has ever seen before. Right. Katie, we have to leave it there, but thank you so much for joining us on this top.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.